am gonna start. My name is attorney Wendy Guthro. I'm a licensed practitioner of law in Massachusetts physically, and I am also licensed to practice law in New Hampshire. I love to do estate planning. I'm an elder law attorney as well, and I do estate administration, probate, Medicaid mass health applications, and also a lot of Medicaid planning with irrevocable trusts to help you preserve your assets in the event of a nursing home 5 years and one day from the time you do planning. So I'm going to bring up the PowerPoint, and we're going to talk today everything about how a will does not avoid probate, but also how can you avoid probate. So let me go to my screen share. Okay, a will does not avoid probate. This is a picture of a courthouse because that is where probate takes place. As I said, my name is attorney Wendy Guthro. Today is February 5th, 2025. All of the laws I will be speaking about today are reflective of the laws that are in place at this time. I am only allowed to practice law in Massachusetts and New Hampshire. And the advice that I'm giving today is really not advice, it's general information. We do not have any attorney-client privilege established during this presentation. It is for general information only. I practice, as I said, in estate planning, elder law, probate, and trust administration, and I'm a member of the National Academy of Elder Law Attorneys. Let's get right into the presentation. What is our agenda for today? We're going to talk about why a will does not avoid probate. We're going to understand probate a little bit. What is it? Consequences of going through probate, strategies to bypass probate, and we'll do some case studies, and then I'll take some questions and answers at the end. Why a will does not avoid probate. This is a quick graphic overview of what a traditional estate plan would look like. A will, a trust, it could be either a revocable or an irrevocable trust. A power of attorney is a document that you would use to oversee your finances. And then there's usually 3 healthcare documents that you can get from a law firm. A healthcare proxy, a HIPAA, and an advance directive. So when we talk about cornerstone estate planning, these are the documents that you would normally find in a plan. What is a will? Because we're talking about how a will does not avoid probate. And most people call me and say, we want a will. And so then we talk about, well, what do you want a will to accomplish? But a will is a legal document that distributes your assets after you pass away to a new owner. And it uses the probate court system to accomplish that goal. So it's a document and it is only used when you pass away. What is probate? It's the legal process of the probate court of authenticating a will and overseeing the transfer of assets to the beneficiaries or the heirs, depending upon whether you had a will or not. So you'll see that in our previous slide, it was just the will, and now you can see the will comes to life when you bring it to the probate court. And because a will is only used after you pass away, you have to get the will authenticated, and you do that by bringing it to the probate court. So here's another graphic depiction of the probate process. You take your will to the probate court, and then the probate court authenticates the will, and it distributes it to your beneficiaries if there's any assets left after the probate process. The probate process is considered to be costly. It takes at least 1 year to go through. It's public, meaning that a copy of your will be placed on record in the court as a public document, so anyone can get access to it. And it has no asset protection strategies built into it when you're going through the probate court system. This is why a will does not avoid probate, specifically because a will has to be taken to the probate court to come to fruition. Let's understand the probate system in itself and that it has financial, legal, and emotional costs associated with it. So here is that graphic again. The probate, the will goes through the probate system into the court. And this is a quick synopsis. I haven't even outlined all of these steps of when the will goes to the court, what happens. First, we take the will to the probate court to open probate. And it is accompanied by a number of other documents and a filing fee, normally in about the range of $400 under current law. The court reviews the will to determine if it was validly executed and validly signed, and if it contains all the things it needs to contain in order to distribute your assets to the named beneficiaries and to pay your debts. So the court determines if all the opening probate documents are correct that accompanied your will. They're going to usually put a legal notice in the newspaper. It's published, or beneficiaries are served so that they can see that they are an interested party and may be entitled to an asset. Even if you possibly have just inherited somebody in your will, they normally have to be served a copy of your will to determine whether they have any rights to contest who you're maybe appointing as a personal representative, or maybe to contest even that you've written them out of the will. Number 5, the personal representative is appointed by the court, short name PR. This is the new language that replaces executor, executrix, administrator, or administratrix. So if you used to use the word executor, you're now going to be using the gender neutral term of PR, personal representative. Step 6, a personal representative letter of authority is issued by the court. And that means that now the one person named as the personal representative has the authority to start gathering up all of the assets of the estate and then paying all the debts of the estate, filing the final tax return of the decedent, which is the legal name for the person that passed away, the decedent. And then after all of those things are done, we do a final accounting after the 1-year creditor claim time period has expired. And then once the final accounting is submitted to the court and the assets are distributed to the beneficiaries or the heirs at law, then we are able to close the probate process. It cannot close prior to 1 year after opening or from date of death. So the costs associated with probate, I mentioned there's a filing fee, and that's one fee, and that varies depending upon the type of probate you're going to open. So that's just one fee. Normally, you're going to hire an attorney to help you with processing the whole probate system. So you're in the range of thousands of dollars for that. So just from that perspective, you have some monetary costs. The legal costs that are associated is that you're opening the will up for everyone in the world to see, which means you're allowing creditors to make claims against your estate, so that the legal costs associated with it is that you might have to defend legal claims against the estate. If Mass Health is involved and is an interested party because you received public benefits from them during your lifetime, they are now going to make a claim against your probate estate. And then there are a lot of emotional costs. And I have to say that this is one of the greatest costs of all. And it normally happens with a lot of sibling infighting over a will. Oftentimes it's who was appointed as the personal representative, or why wasn't I, or why was she or he? And then it's just a very long process that normally takes place when the personal representative and family members and friends are grieving the death of the decedent. So it's very difficult, I find, for many clients to be able to pull it together enough to start to follow that multi-step process and get going with probating someone's estate when they pass away. Part 3, the consequences of probate. So the consequences of probate are really the reasons why you should avoid probate. So the probate process in Massachusetts is time consuming. It takes 1 year at minimum. If you have a contested or complex estate, it can take years to settle. And I cannot underscore this enough, that the minimum amount of time probate is normally opened is 1 to 2 years. But if you have any problems with any of the assets, such as if you have a home and it's being sold, and maybe that there were some old mortgages that you had from 50 years ago, and you didn't clear the title, the chain of title, that you had a release of your mortgage because it was paid. So all of these things are going to take a lot of time to go back to the mortgage company if they're still around. If they're not, then we're going to have to go to whatever company or bank took over that mortgage, right? And then we're going to have them go into their files from 50 years ago and find that you did pay off the mortgage. And then that gets recorded at the registry of deeds. And then we can go and sell the house. So there's just many issues that can derail an estate to take much more than the 1 year minimum. So also, complex estates, if you have multiple assets or multiple beneficiaries or many different types of assets, or if you have assets located in a foreign country or in different states. So those things can create a complex estate that will take much more than the 1 year to settle. Court, accounting, attorney fees, and tax filings add considerable costs to doing a probate. The probate process is public, as I mentioned earlier. Your will is filed at the probate court for all the world to see. So it is not a private transaction. So if you are giving large sums of money to anyone, those large sums and the final accounting will be recorded at the probate court. So this is a public process. And if you have no will, that the state decides who will get your assets under the current law that's in place in the year that you pass away. So there are many more reasons, to be honest with you, to avoid probate. But as a quick summary, these are some of the top reasons why most people like to avoid probate. And again, why are we even talking about wanting to avoid probate? Because a will does not avoid probate. So if the only document you have in your estate is a will, and all of your assets are named in your individual name, and that they don't have any named beneficiaries on assets, you are going to be taking your will to the probate court to open up probate. And so these are some of the reasons why we don't want to go through the probate process. So these factors make it worthwhile to consider alternatives, such as using a trust to avoid probate, keep matters private, and streamline the distribution of your assets upon your passing. So let's talk about strategies to bypass probate. The number one thing I say to my clients they can do is to do gifting during your lifetime. I often see clients do this when it comes to jewelry or items of sentimentality, or sometimes furniture if they're downsizing, right? They're going to be moving maybe from their home into independent living or assisted living. So gift during your lifetime is one way that you will easily avoid probate. You can jointly title assets. So very common with husband and wife, or partners, or a parent and a child. two siblings, two friends. So these are very common ways that we can also avoid probate by joint titling assets. Number three is that you can designate beneficiaries on certain assets, not all, such as the deed to your real estate. If you own it individually, you don't normally say on the deed itself who's going to get it when you pass away. So that's not an asset that carries a very simple way to designate a beneficiary. But a beneficiary statement on a CD or a retirement account, those are very common uses of how you are going to use designating beneficiaries as a way to avoid probate on a particular asset. The next thing is you could create and fund trusts. It could be a revocable trust, which is very common for estate planning purposes. It could also be an irrevocable trust, such as a Medicaid asset protection trust, if you wanted to start the 5-year look-back period for Medicaid planning. So if you create a trust and then fund the trust, and funding a trust is simply taking an asset, maybe like the deed to your home, and transferring it out of your individual name, but into the name of a trust where you would be in charge of that trust and you would also be the beneficiary. So we're going to talk a little bit more about trust because it's a very common technique for avoiding probate. But again, lifetime gifting, titling assets in more than one person's name, designating a beneficiary on a beneficiary statement on some particular assets, or using trusts. So how to avoid probate using trusts? Let's first talk about what a trust is. It's a legal entity that can hold your assets during your lifetime and distribute them after your death without using the probate court system. So if you can imagine that a trust is simply a container to hold things, that will make a little bit more sense, because if you have this container, you're going to fill this container by funding the container with whatever assets you would like to avoid probate on. So this container has three roles: the grantor, the trustee, and the beneficiary. So the grantor is usually you if it's a revocable trust, and it's the person who creates the trust and transfers their assets into the trust container. The trustee is normally you as well. It's the person who's in charge of following the trust instructions. The trustee manages the trust for the benefit of the beneficiary. So if you are the grantor, the trustee, and the beneficiary, then you're in charge of every role, and everything that's in that trust is yours and you're in control of it. The beneficiary, as I just said, is usually you during your lifetime on a revocable living trust. We are not speaking about an irrevocable Medicaid asset protection trust right now. In this terms, in my example here, we're talking about a revocable living trust. So a beneficiary, normally you, that you get to use, the assets that are held in this container during your lifetime. And then upon your passing, we would normally say that your heirs at law, or your children or friends or charities, are going to be the beneficiary of the assets that are held in this container after you pass away. You may also name your spouse, your children, your friends to also be beneficiaries during your lifetime, but it's not very common. So you can avoid probate using trusts. In this example, is that you transfer your assets into a trust to avoid probate. So there is that container again, right, in the bottom. This time it's a revocable or an irrevocable, right? It can be either one. And that you take your real estate, we would take the deed and we would take it out of your individual name and do a deed transfer at the Registry of Deeds. So for me, if my deed currently says that attorney Wendy Guthro owns her home, and I'm going to now create this trust for myself, a revocable living trust, and it's going to be Wendy Guthro, trustee of the Guthro Living Trust. So then we're going to record a new deed at the Registry of Deeds, and that is how you fund assets into your trust. You could do the same thing with bank accounts by simply taking your trust document to the bank, showing them that it's yours, you're the grantor, you're the trustee, you're the beneficiary. It's going to use your social security number if it's a revocable living trust, and you're going to retitle the assets, your bank accounts, into the name of the trust. And that is how you fund the bank accounts, CDs, brokerage, doesn't matter, into the name of the trust by simply taking the trust document to your financial institution, asking them to retitle it into the name of your trust. So anything that you get into your trust prior to your passing will avoid probate. And then the trust controls how the assets will be distributed upon your passing. It does not use the probate court system. When you are dealing with the trust, it's a non-probate event. So you have the trust and you appoint the trustee. You are the trustee during your lifetime normally on a revocable trust. And then you can name a successor trustee. And then that successor trustee is now in charge of doing a lot of the things that your personal representative had to do in the probate environment, right? They have to read the trust. Maybe they're going to hire an attorney to help them decipher everything that is said in the trust. And then what you're going to be doing is paying all of the debts of the estate. You're going to be filing tax returns, and you have the authority to do that as the successor trustee of the trust. And then once everything is done and a final accounting is still prepared, and you're going to distribute in a final accounting to the beneficiaries of the trust so that they can make sure that the trustee gave them the right amount of money and distribution of assets that they were entitled to. So you can see it's a very similar process, but the biggest part is that you're not involving the probate court. It's much more of an immediate process. You don't have to wait a full year. It's private because we're not recording anything at the Registry of Deeds or, excuse me, at the probate court. We could be filing a new deed to real estate at the Registry of Deeds, but the privacy takes place in that we are not going through the probate court system, and that there can be some asset protection strategies involved with trusts, especially if you're doing an irrevocable or irrevocable Medicaid asset protection trust. So we started on a will versus now the trust. So the will, legal document that distributes your assets after your passing to the next owner of the asset, right? The beneficiaries, but it uses the probate court system to do that. Versus a trust is a legal entity that can hold your assets during your lifetime and distribute them without using the probate court system. This is a graphic depiction of what I had just said. The probate court system using the will, and the non-probate court system using a trust, as well as the other three things that we had mentioned, right? You don't even need to use the probate system if you have gifted something during lifetime to somebody, right? If it's a jointly titled asset, it will avoid probate. And also if you have a named beneficiary on an asset, it will avoid probate. So trust and estate planning, whether it's revocable or irrevocable, they can accomplish probate avoidance, asset protection using the irrevocable trust for the Medicaid planning. They control and manage assets very efficiently compared to having a jointly titled bank account here, a bank account maybe with a beneficiary on it, um, a brokerage account that might have somebody else in charge of it. So if you have a trust and you fund the trust, you're managing the assets and controlling the distribution of those assets all in one place. So that if maybe one of your children or friends fell out of favor and they were named beneficiary, or they were joint title owner, right, on an asset. But if you have all of your assets held in a trust instead of being jointly titled or having beneficiary statements, you are going to one place that is just the trust and making one change to the beneficiaries of a trust so that upon your passing, the assets are all controlled by this one document. It can minimize estate taxes, a revocable trust or an irrevocable trust, but specifically for married couples, the revocable trust, you can do a revocable trust that has tax planning in it for estate taxes so that we are using the first spouse to die's Massachusetts $2 million estate tax threshold. And if you're lucky enough to have a lot of wealth, which is currently over $13 million for the federal estate tax upon your passing, so that there are techniques and strategies we use. They're called credit shelter trusts that can be used with estate planning with trust. So another benefit that trust can accomplish is to minimize estate taxes. And the other thing trust can do is provide for special needs individuals as well as disability planning. And how that takes place is that if you have a revocable trust, or any type of trust for that matter, and you are going to make a distribution to a child right now, and they're young and they seem fine, but that in 20 years there's an accident and they end up disabled and on public benefits. Well, if a trust is a good trust and drafted appropriately with special needs language in it, you would avoid disturbing an individual's public benefits. And we would still give that individual assets, but it would be held in a supplemental needs trust and be distributed for the benefit of that disabled individual, but in a manner that would not disrupt their public benefits. So this is a key point, I think, that a lot of people don't think about when they are naming someone as a joint owner on a bank account, or naming all of their children as beneficiaries on their brokerage account, that you can't foresee things that are going to happen. So on a brokerage account, say that you have one of your children named as a beneficiary, and they have had this accident and now they are disabled and on public benefits. Unless you had the presence of mind to go and remove their name from that brokerage account, that money has to be distributed, has to, by law, be distributed to that disabled individual, and it will usually kick them off of public benefits. So using a trust is just a great technique to have a lot of planning to avoid probate as well, because as we all know, a will does not avoid probate. So we're going to go now and give some examples of probate cases so you can kind of get a flavor for what does and does not avoid probate. I'm going to show you the fact pattern, and then it's going to have a list of assets on one side. And I want you to start to think, if from what you just learned, whether that asset will or will not avoid probate. Number one, Harry and Wilma, husband and wife, married with 3 kids. Harry dies with a will. So this is what we said, right? A will does not avoid probate, but let's see what happens with Harry. Harry's assets, he has a $25,000 IRA, and he named Wilma as his beneficiary. He has a $50,000 individually titled bank account. He has a $50,000 joint bank account with Wilma. He has a $5,000 term life insurance policy, and he did name Wilma as the beneficiary. And he has a $750,000 house, and it's jointly titled with Wilma. When Harry dies, will any of his assets need to be probated? Well, he will not have to do probate on the $25,000 IRA because he has a beneficiary. The $50,000 individually titled bank account, he will have to probate because when you look at that bank account, you can't tell who gets it next, right? There's no indication of a beneficiary, a jointly titled asset. It's not held in a trust. So we are going to go to probate on that individually titled bank account. $50,000 joint account with Wilma, that's going to avoid probate. The life insurance has a named beneficiary, no probate, and jointly titled house, no probate. So Harry's individually titled bank account is the only asset that will need to be probated. Case study number 2, Harry and Wilma, they're back at it, married still. Harry dies, then Wilma dies 2 months later with a will. So let's see what Wilma's assets look like. 25,000 IRA. Oh, that's the one she inherited from her husband. And she didn't get a chance to name a beneficiary on that asset. $50,000 jointly titled bank account with her son. They did that right after Harry passed away. $50,000 joint bank account with Harry. She didn't get a chance to retitle that one. And a $750,000 house jointly titled with Harry. When Wilma dies, will any of her assets need to be probated?
All of them except for the jointly titled bank account with her son.
Yep, I hear someone chiming in. Yep, so we have the $25,000 IRA avoids. It's going to be probated, right? Because they didn't get to get a new name on that. And this is something I have seen happen a lot. Right after somebody, a spouse oftentimes, or a partner passes away, you're just too grief-stricken to really try to do much. So, excuse me. So it's not unusual that we can't make moves quickly to get the retitling changed. The $50,000 jointly held account with her son will avoid probate. Everything else is going to probate because we can't tell by looking at the title of the asset or a beneficiary designation who gets it next. So most of Wilma's assets will need to be probated. The non-probate asset will go to her son, her one son named on the account. And by the way, that one son, that she simply added him to that account for convenience because she has 5 other sons, right? That one son named on that bank account has no legal responsibility to share that account with any of his other siblings. He can if he chooses to, but it's important to know that when you name one person for convenience on that bank account, or just because you're stating they're going to be a signer on that account, they're going to be a joint title owner, they now have the legal authority to possess all of that money upon your passing as a surviving joint owner. The last case study I think it is case number 3. Harry and Wilma are back at it again, still married. They have a trust, naming themselves as the grantors, the trustees, and the beneficiaries. Successor trustees and beneficiaries are their children and or grandchildren. All of their assets have been transferred into the trust or named the trust as a beneficiary. So they have individual and joint assets that are held in the trust. The $25,000 IRA, we don't ever normally cash IRAs out to retitle them into the name of the trust, but some trusts, specifically if they have accumulation language in them, you can name a trust as the beneficiary of an IRA. A $50,000 bank account is titled in the name of the trust. A $50,000 investment account is in the name of the trust at, Schwab, Fidelity, a brokerage home. And then their house was titled in the name of the trust. We did a deed transfer prior to either one of them passing. When either of them dies, will any of these assets need to be probated? All assets held in trust, no probate is needed when either of them dies because they funded a trust as the cornerstone of their estate plan. So why should you consider a trust? A trust specifically avoids probate. It's private and immediate. It plans for the disabled or disability now or later. A tax trust can reduce or eliminate an estate tax, and an irrevocable trust can start a 5-year look-back period. So that's reasons to use a trust. But again, like I said earlier, giving gifts during lifetime, also using the beneficiary statements or joint titling of assets. So we are going to move into the last part of this presentation, which is taking your questions and answers. I'm going to take a quick look in our chat session. Wendy, how often should we update our trusts? Well, that depends upon what the terms of your trust are and if they meet what your intent is. So that if you have a trust and you have it fully funded and it meets all the conditions that you need to under your current beneficiary designations and your relationships that you have with your fiduciaries is a general term that we use often for who are your successor trustees. Fiduciaries are people that you trust emphatically, and it is their job to make decisions in your best interest, not their own. So if a trust is very old, sometimes it's worth having it evaluated. There was a recent change with the Massachusetts estate tax limit. So if your trust specifically had language in it naming that a certain dollar value was going to be a catalyst for an event to take place of paying taxes or a distribution to one person or another. So if you find conditional language in the trust itself that might create an event that you don't want to take place now, that might be a reason to update it. Some law changes sometimes require that you should look at the language in your trust. So those are certain things that could require you to consider looking at your trust. I would say if your trust is over 20 years old, I would definitely recommend at least taking a look at it. And the easiest way to take a look at it is go back to the firm who drafted it for you, because they will know your trust and the trust language better than any new attorney. You will have to pay a new attorney an hourly fee normally to do a trust review. Some attorneys have a flat fee rate of $1,000 to review a trust because it's very complex and you really have to go through it with a fine-tooth comb and look at every clause, because there really aren't a lot of cookie cutter trusts. Trusts differ greatly from trust to trust. Another question here is, I have recently been told that a Roth account cannot be held in a trust. Is that true? So if true, how can the Roth be protected? So it is true. And that is because a Roth is an individual retirement account. And an individual retirement account can only be held by an individual. And a trust is not an individual. It's a legal entity. So a retirement account, whether it's a Roth, an IRA, a 401k, a 403b, all of those are assets that require an individual to own them. Because when you start taking distributions from a retirement account, oftentimes they're based upon your age. such as a required minimum distribution, is distributed over your life expectancy normally. So you can't put it into a trust if you want to keep the taxed advantage savings of that asset. So on a Roth, right, your investments are growing tax-free. And it's because it's in this individual retirement account. If you take it out of that, you're not going to have those same benefits. I will mention, though, that these types of questions are somewhat above my pay grade because I'm an attorney, not a financial advisor. So I do suggest that you speak to your financial advisor about these types of questions. As an attorney, I believe in the three-legged stool approach to all assets, legal questions, things like that. And the three-legged stool approach is that you should have on your team an attorney, a financial advisor, or and a tax professional to help you make decisions on kind of whatever is going to come down the pike. Because of those three professionals that you're going to have, that three-legged stool approach, you will likely need one of them to help give you advice on whatever your dilemma or situation is. So think about that. Think about using that three-legged stool approach of having someone to help you with your financial decisions, having a CPA tax professional to help you with the tax effect on any kind of transfers or distributions, things like that, and then an attorney to help you understand the legal effect of the move that you want to make. And if true, how can the Roth be protected? Are you looking to protect it from Medicaid, from in the event you need a nursing home? I'll speak to that, and if it's not that, then please post again. So it is next to impossible to do Medicaid asset protection planning to start a 5-year look-back period on assets that are held in a retirement vehicle. And that is because if you want to maybe gift it away or transfer it into an irrevocable trust, a Medicaid asset protection trust, then you have to transfer it out of your name. And that is going to create a taxable event that the entire amount that's in that asset that you want to start protecting is going to be distributed to you. You're going to have to pay taxes on it when you take it out, and then, or you're going to get a 1099 at the end of the year, and it's going to show as a distribution of ordinary income and added to your tax return that year. And for large retirement accounts, it will put you into likely the highest tax bracket for Massachusetts and federal, or New Hampshire, or whatever state you're in. So what I say to my clients, if we're going to be doing some Medicaid asset protection planning, is that we are going to be looking at strategically figuring out, should you be spending more of your retirement money and taking maybe a higher amount than the required minimum distribution and paying taxes on that gradually, and then taking your non-retirement money, creating a Medicaid asset protection trust, and then start funding that. And so say if you put $100,000 in your irrevocable trust and you started the 5-year look back period on that, and then you just took larger distributions from your Roth or your traditional IRA to use for living expenses. Now, it's going to be very unlikely you're going to find a financial advisor that would really encourage you to do that without them really knowing what your plan is, right? Whether you are trying to do Medicaid asset protection planning. Because if you're trying to do Medicaid asset protection planning, you're in a completely different genre of investing and spending, right? Than you are if you're approaching your financial advisor and say, okay, let's get some growth stocks going, reaching retirement age. I'd prefer to start doing more bonds. And, so your investment strategy and your distribution strategy from your retirement assets and your non-retirement assets is going to be completely different. So I do want you to have a very broad view of what is your goal. And that's even what is your goal of whether you're going to do a trust or not, right? Maybe you're going to do a retirement, an irrevocable trust for the Medicaid planning. Maybe you're like, you know what? I worked long and hard for my money. I'm really okay with privately paying in an assisted living facility, in an independent facility, maybe a CCRC community, a continuous care retirement community, or in a skilled nursing facility. And you're going to choose the one you want. Or you're going to keep your money and you're going to privately pay and bring in services in your home. Maybe you're going to use that money to modify your home, right? Get a chairlift or get a ramp, or if you're very disabled, you're going to bring in a Hoyer lift and you're going to have around the clock care so that you can stay in your home environment. All that costs, right? You can't put money into an irrevocable Medicaid asset protection trust and then think if you're going to go potentially into a nursing home later on down the line, you can't use that money. You have to divest yourself of that money on paper. It's no longer yours. You're giving it away. And that's how you start a 5-year look back period, right? You have to divest yourself of that asset so that on paper it is very apparent to Mass Health when you submit your application that you don't have any money. You're allowed to have $2,000. If you have a partner or spouse, you're allowed to have 150. They're allowed to have $158,000. So it's about 160,000. You're allowed to prepay funerals. You're allowed to have $1,500 burial accounts. You're allowed to have an insurance policy worth $1,500. And you're allowed to have personal property and a car, one car between two people. So, or one person. Not a lot. So, but again, you need to, when you're thinking about what type of estate plan you're going to do and what kind of strategies you want, you have to think, what is your goal going to be for your life? What do you envision your life? If you want to keep hold of your money to be able to privately pay for your care in whatever setting you want, then you do not want a Medicaid asset protection trust. The other thing I said earlier is that you've worked long and hard for your money, right? So I want you as my client to do what you want with your money, and I want you to have your best life. Even though most of you are going to say, if you have children, I really want to leave a legacy. At this point in our lives, most of our children are making more money than us. And so I think everybody should really think about having your best life and making sure that you can get the care that you want. So maybe holding on to your money. The other thing is that it was easier to say this under the last administration, that they were doing a lot of planning to try to figure out social programs to enable us to age in place in our home and not have to go to a nursing home to get that high level of care, or that it was just trying to be made a little bit easier for social programs to be available to us, so that they were really going in that direction. So I'm hopeful that this new administration is going to continue things on in that vein so that maybe we don't have to work so hard about hiding away our money, right? And realizing that we are aging, and that the old process was that we were living in a nuclear environment with our children, our great-grandchildren, our parents, our great-grandparents, our grandparents, all living under one roof. And we all lived in the same town. So the government did not plan for having to pay for people's nursing home care because these people were being cared for in the home. And that's kind of where we're trying to get back to: how can we care for people in the home environment, or in a environment of their choice? It could be in an assisted living facility, right? But that we don't have to force them to go to a nursing home just because, right? That the system is set up to have you just liquidate all your assets or give them away 5 years in advance to then be at an asset level that you can now have the government pay for your plan. So I think I went on and on about that last question, but we have one other question, or maybe a couple of. Can you explain the difference between revocable and irrevocable trust and pluses and minuses of each. Well, that is a presentation all unto itself because that is a very robust question, but I'll do the helicopter view of it. Revocable. By its name, it can be revoked, changed, modified, terminated, torn up, right? And on a revocable trust, normally you are the grantor, right? You're the trustee, you're the beneficiary. It's equivalent to you holding the asset in your own name, but we put it in this entity, this container that's now your trust, and you can do anything you want with anything in that container. Now let's talk about the other side, the irrevocable or irrevocable trust. Again, ir means cannot, right? So it cannot be revoked, modified, changed, terminated, unless the terms of the irrevocable trust state how those things can take place. So I'm going to speak mainly about a Medicaid asset protection trust because those are the irrevocable trusts that I do for asset protection planning the majority of the time. So an irrevocable trust is you create the container. The words on it are completely different than a revocable trust. You are the grantor. That was the first position on my diagram, right, of the 3 positions in the trust, the grantor. The trustee, you are not the trustee because the trustee is in charge of the assets. The trustee is the one that says, okay, I'm going to make a distribution because the terms of the trust say that I can. And the beneficiary bifurcates because you are now the income beneficiary of the irrevocable trust, but you are not the principal beneficiary. And that's what I mean by bifurcate. It goes in 2 different directions. So you are the grantor because you created it. You are not the trustee because you're not in charge of it. And on the bifurcated beneficiary distributions, you are entitled to the income generated from it, but you are not entitled to the principal. And I will give you a quick example. $100,000 brokerage account. You have it to pay dividends, and you're getting dividends of about $1,000 a year. You transferred it into the irrevocable trust. You wanted to start the 5-year look-back period on it. Every year, you're going to get a distribution and a 1099 for $1,000. The trustee of the trust is required to give you that $1,000. The $100,000 you can never get at because it's an irrevocable trust and you are not the principal beneficiary. A second example, you transferred the real estate, your house, into the irrevocable trust. Start the 5-year look-back period. First year, you're living in the house, no income to give you. The children are normally named as the beneficiaries of the irrevocable trust, the bifurcated, right? Income to you, principal to the kids. So there's no income in the first year because it's a house, you're living in it. Second year, third year, same thing. Fourth year, you decide you're going to go into an assisted living facility, have the time of your life, live in this social-based model. You don't need any care, but you're just going to go for the movies and the food, right? And the daily happy hours. So you want to fund your income. So you're going to rent the house and you're going to clear maybe $20,000 a year off the rental after you pay all the expenses. You get the $20,000 in income to use for your assisted living. And the children still have the principal house, but you can't get at it. And now you need to go into a nursing home. You're through the 5-year look back period and you still haven't sold the house, right? So you still have the money and maybe you're still doing the rental. You're getting that 20,000. So if $20,000 is coming to you in income, when you do a Medicaid application to go into a nursing home, you have to report that $20,000 in income. You've gotten through the 5-year look back period. So the principal is protected, right? So the house is protected, but that $20,000 is not because it's yours and it's income generating. And that has to be reported on the Mass Health application. And that if you're the only person, right, alive at that time, they're going to take the whole 20,000. And they're going to take your Social Security or your retirement account. Well, you won't have a retirement account. You'll have to privately pay until you get below the $2,000 limit, asset limit. And then they'll just use everything over that. For income, you're allowed to keep $72.80 a month of all your money if you go into a nursing home. So I hope that was not too much of a long-winded answer for the difference between a revocable and an irrevocable trust. They're completely different animals. I get a question a lot when people do the revocable trust and say, okay, so can I just come back and you can change this if I decide I want to do an irrevocable trust? Absolutely not. No, 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 no. They are so different. And that is asking for Mass Health to evaluate that trust. And when they do, and they see that, oh, you used to be able to do this and you used to be able to do that, they're going to say, we're going to make a determination that this trust doesn't pass muster to qualify as a Medicaid asset protection trust. And even though you got through the 5-year look back period, the underlying assets are now going to be counted as an asset that they can lien. So the next question was, Eileen, does a trust help avoid lawsuits while alive? If it's an irrevocable trust, it does. In a car accident, if a person I hit sues me. So if you put your house into an irrevocable trust and you have a homestead protection, even if it's not, right? A homestead will really help you the most in that situation, that they won't be able to lien your house. But the other assets, Eileen, without being in an irrevocable trust, they would be able to get at it. In case study number 1, if there is one thing that needs to go to probate and other items don't, does the probate, I have to move this, sorry, does the probate action hold up everything else from getting settled? No. We normally do simultaneous probate and estate administration. That's what the other avenue is called. And my concern with an unprotected Roth is, can it be taken by family members with whom one is not on good terms? That depends on if you have named them as a beneficiary and you pass away. Because a Roth terminates and gets distributed to new beneficiaries only upon your passing, or if you pull the money out and put it into your bank account and they are maybe on that bank account with you as a joint title owner, then they can get at it. So can it be taken by family members with whom one is not on good terms? So no, and that if you name the family members that you are, in good graces with, right? If you have named them as a beneficiary and have not named the other person that you aren't on good terms with as a beneficiary, then The Roth will just be distributed to those named beneficiaries on the beneficiary statement. So those are all the questions I have here. Anyone is welcome to unmute if they'd like and ask any general questions, but to finish it up, in case anyone's going to pop off, thank you all for coming, and hope you enjoyed it, the webinar, the presentation. Hope you found it useful. As I said at the beginning, I do estates, I do probate. It's a big part of our practice here. Estate planning is the majority of our practice. As a member of the National Academy of Elder Law Attorneys, I'm well versed in the irrevocable trust as well, and understanding the rules for Medicaid asset protection. And that you're welcome to go onto our website, which is my last name, Guthro, and then law, guthrolaw.com. I have a number of videos on the website under video resources that you can continue to educate yourself on these different topics that are there. There are some things on the difference between revocable and irrevocable, as well as Medicaid asset protection trusts, and just how a will does not avoid probate. So I encourage all of you to make sure that you use some of the techniques that we've used here to avoid probate, but look at your situation and who is going to be the beneficiary of your estate. And I think that should help guide you with what you need to do next. We do offer consultations for estate planning. It is a free up to 1 hour consultation. You can simply send us an email to office@guthrolaw.com, and we will then send you a link to a questionnaire. You complete the questionnaire online, or if you need one sent to you, you could just let us know that, and we will send one to you. But online, you just touch a button, it comes back to us, and then we contact you to arrange a free consultation, normally by Zoom, if that's available to you. If not, we can do it in person, but Zoom seems to be the preferred method. And then we kind of sit down and discuss, this is your situation, this is what you want, this is what we would recommend for a plan. We'll quote you pricing at that consultation or send you a quote. If you're ready to move forward, you can just get an engagement agreement. And then once the engagement agreement is received, normally you are sitting down, signing your documents 4 weeks later or less. So we try to move things along because we know it's hard to get to this point, right? We know it's very hard, and that once you're here and you're ready to do your estate planning, or if you already have an estate planning, right? And it involves a trust or not, but if you need a trust, then maybe we're just going to do a new trust and a new will and use all your other documents. But we'll price you out for whatever it is that you need. The different other types of consultations are probate or estate administration, or for irrevocable trusts, because those are very detailed. Those are billable consultations. And that you can just contact us for a rate for those consultations. But it's been a pleasure.
If you would like help or have questions about this information, please give us a call at 781-229-0555 or visit our website at guthrolaw.com. We look forward to hearing from you.